Okay, we're getting this party started. Before we start, just a couple of things. I'd ask if you've got a cell phone to please put it on mute or silent. And feel free to ask questions. You know, if there's no dumb questions, only questions that just don't get answered. Welcome to Give Love to Your Family, Advanced Directives, Speak for You When You Cannot. I am Cynthia Val Chapman. I am going to be your workshop leader today. And I want to welcome you and thank you for sharing some of your time with me this evening. A couple of housekeeping things. If you got a cell phone, please put it on silent or mute. I encourage you to ask questions. There's no dumb questions, just ones that don't get answered. And share. You know, if you got a story that you'd like to share, feel free. Since we have the room to ourselves, we can take as much time as we want. So, having said that, I am just a little bit about me and why I'm doing this. I'm a Pulitzer Prize nominated ghostwriter, and I have worked with families who are experiencing transition. I'm doing this because I feel like our community in particular does not get the information that they need to make decisions that protect their legacy. We typically don't have the same circles of influence that other communities have access to. And as I worked with families who are experiencing transition, and as I worked even in my own family, I realized that there are a lot of documents that are associated with dying and the end of life that we don't really know anything about. And so I wanted to do this workshop to provide the information to the people who come, so that you can then share that information within your own circles of influence, so that we begin to transfer information and treat information as an asset that needs to be transferred, just like our physical assets need to be transferred. So we're going to talk about what you can control about dying, and understanding what advanced directives do and what they, how they're used, and how advanced directives fit into an estate plan. We're going to go through the documents. We're actually going to fill out, that's why you have copies of all the documents here that were down, and by the way, those documents are downloadable from the Department of Public Health website. And I have the resource listed at the end of the presentation. But you can fill these documents out, and when you then all you have to do is get them notarized. In the case of some of the other documents in the other packet, once you complete those documents, you will be able to give that to an attorney and say, okay, here, this is all the information you need. They can put together your estate plan, they can do your advanced directives, all in one fell swoop. All righty. Good, you can't see that. That was just my little intro thing. All right. You know, we plan for everything. We plan for weddings, we plan for births, we plan for vacations, we plan for proms. The one thing that we know that we can control, that we know is going to happen, dying, most of us don't plan for. And maybe it's because you don't know the time or the place or the means, that we don't want to think about it. Or maybe, there's some folks that believe that if you talk about death, you're going to hasten its arrival. I don't believe that. I think that there are some things about death that you can't control. And those things are the kinds of medical treatments that you do and do not want at your end of life. You can control, or at the very least, indicate where you would prefer to take your last breath. You know, there was a study that found that, a survey that found that 80% of people said they want to die at home. Only 20% wind up dying at home. That 20% planned 9 times out of 10. They had advance directives in place. They had a living will in place. They had communicated their wishes, and so their family and the person that they empowered to act as their proxy knew that, okay, I don't want a whole lot of life extending things done to me. I want to be comfortable. Those are the kinds of things that basically become quality end of life versus quantity end of life. And those are the kinds of things that advance directives let you address. Those are the areas of dying that we can control. Simply put, advance directives is really an umbrella term. And they're used to describe any legal form that guides your future medical care. They can apply in cases of injury or illness or permanent, if you're in a coma, permanent vegetative state. And they come into play when you can no longer make decisions for yourself. Although there are differences in the forms from state to state, most states will recognize the following types of advance directives. They are, living wills, medical powers of attorney or healthcare power of attorney, the advanced healthcare directives, psychiatric advance directives, do not resuscitate orders, and financial powers of attorney. A living will sets out the medical treatments you want after becoming incapacitated, and it allows you to state what types of medical care you don't want, such as undesired treatments like dialysis or going on a ventilator, other life-preserving care. Unlike a last will and testament, living wills don't address your assets. They don't have no provisions for your assets. And living will forms address your health care choices toward the end of life. This is primarily used for terminal situations. Let me go back. Medical powers of attorney, that's a really important document because that is the person Alonzo, that you empower to make decisions on your behalf. That person, and depending upon the scope of the powers that you give to them when you appoint them as a medical power of attorney, that can include making decisions about disposal of your remains, organ donation, whether or not you want to be on a feeding tube. So it's a pretty significant appointment. And so when you select a medical power, when you select a surrogate or a proxy to be your medical power of attorney, you want to make sure that you are choosing someone that you have, communicated, I'm kind of getting a little ahead of myself here, but that you have communicated your wishes to, and someone who has enough backbone to say, no, she doesn't want that. This is what she wants. Because there are times when what the family wants, what family caregivers may want, different treatment options that the patient individual themselves may not want. And so it's critical to have somebody that can stand up to them and say,
if it's the family, is it like a conflict of interest in the sense that if this person goes, it gives them more power in terms of expediting their leave? And for example, if a friend of mine, his dad was 98,
mm-hmm.
and I'm thinking his sister is a lawyer, and right now she's getting the medical power of attorney.
Mm-hmm.
But financially, both of them would benefit. I'm kind of seeing, personally, I feel like they need a third party, because to me, it's a conflict of interest with the sister being a lawyer and the son living with the dad. It's- I don't know, maybe it's just me, but it seems kind of cold in that right now they're deciding about him having a heart operation. And they're looking for well, they found a doctor from Northwestern that can do this operation, but, like I say, he's 98 years old.
Hmm.
And he's the one advocating for it, and the daughter, as I said, is an attorney, and she found the doctor that does this,
Mm-hmm.
and she was looking at the percentage of cases that do well. But I'm also looking at the fact that he's 98 years old, so I don't know why he's going for this operation. So yesterday they had a conference with the doctor, with the dad, and with the daughter. The son was the facilitator for the Zoom meeting that they had.
Mm-hmm.
But to me, they're more interested in the money that the dad is leaving to both of them, because like the daughter has the medical, the son had the medical power of attorney, but he discovered that the dad had that medical power of attorney dated back to the 80s.
Okay.
And the daughter is verbally given doing all this medical power of attorney. And the son, like I said, he lives with him, but I don't know, it's something missing there to me. What I'm trying to say is it seems like they need an intermediary or a middle person to be more objective, and even to talk to the dad and say, well, what's wrong with you that you need a heart operation at 98, And he's thinking, I don't know if he's thinking, I'm going to make it to 100 or beyond that in terms of getting this operation. The daughter, like I said, she has researched and done some things with different medical people, so she knows them, and she found this doctor from Northwestern that can do this operation for him. So I'm just looking at it, trying to be, how should I put it, as onlooker as I can be to them, and trying to stay in my lane since I'm not family.
Mm-hmm.
But there's a sister part of me who wants to say something smart. And
Like, why are y'all operating on a
98-year-old man, exactly.
yeah, and they're white, so they have blue guys of money, and they have blue guys of influence, but I mean, it don't make sense to me.
Well, it doesn't make sense to me either. And, as far as the intermediary, I would really feel like if the dad is of sound mind and capable of making his own decisions, that maybe the conversation needs to be had with him, because as long as, that's a tough situation.
If he has to make the decision, like you said, if he is of sound mind and memory, it's not even body anymore. I found a sound mind and memory. He can make those decisions. But if he picks out who he wants to have his medical power of attorney, then they will make the decisions. Even if it's his son, his daughter, whoever it is, he gives them the authority to do that. And it does not become a conflict of interest only if it was someone being the executor and benefiting from it. It doesn't have anything to do with conflict for a medical power of attorney.
But if she is the medical power of attorney and the health power of attorney.
Same thing.
This is the
Those are
same thing.
Okay, and also she's the financial person and the medical person. That's not conflict.
No, she can be both. If he appoints her to be both.
But she seems to be being appointed both.
Right.
Okay. Yeah,
The son feels slighted because the dad is not communicating with him, even though they live together.
And the father might have more trust in the daughter because you pick the person that you feel will do the right thing by you.
Okay.
Right.
As we know, and we're in the same field, as we know, whenever there's any issues about death, I always tell people it brings out the best and the worst in people.
It absolutely
So,
does.
he might very well feel like the daughter has his best interest at heart.
I question the person.
Father makes that decision, and that's, that's what they have to live by.
Mm-hmm. That's okay. I welcome the input because I'm
I just thought that with the daughter being a lawyer and the daughter benefiting financially and the daughter choosing the doctor, to me there's some kind of conflict there. It's not-
No, the only conflict that would be if you got into the legal stuff about the daughter being the executor of the estate and benefiting from it. There are some legalities
She is-
involved in that.
She is gonna do that.
Well, it depends on if he's appointing her to be his executor,
Okay, I think he will be.
and that's fine. I think
Well-
that's fine.
It's not a conflict.
no. It really as long as he's in sound mind and sound memory, then his choices are valid.
Yeah.
And however he wants to distribute that authority among family members or non-family members, that's totally up to him. You might, I don't know how close you are to the family. I'd be curious to know if, what documents he already has in place.
Well,
Be-
the son told me that he thought the dad was playing games with him because he had the medical power of attorney. He said he had medical power of attorney, but when he saw the documents, they were dated back to the 80s. So he said they were not valid, and that the dad knew that they were not valid.
I don't know that there is a time limit on the validity of a medical power of attorney. He can revoke it and appoint somebody else, but as long as he was a sound mind and memory when he did it, and he still is, it's valid.
Right.
So he felt that it wasn't, the dad wasn't being honest with him, so he thought he was playing games with him.
Well, there's a whole lot of family dynamics that especially when there's money involved, things that we just aren't aware of. So, the best I can say is that as long as he has his documents in order, however that shakes out, will be how it shakes out.
The daughter feels that when he mentioned this operation, they were going to go to this doctor. This doctor that he's been going to is at the University of Illinois. And with her medical background, her legal background, she found this doctor from Northwestern that does this kind of procedure. And so she recommended that. So they had this conference yesterday between the doctor, his daughter, and, the dad. So he seems that he wants this operation, that's what they're saying. But I'm looking at, her finding this doctor, and I don't know what the success rate is, nor do I understand why he would want it at 98.
Well, that is the question right there. And maybe that's a question for a counselor, a trusted advisor, or somebody to help him take a look at that. Because is he healthy? Otherwise,
He's driving, he's got a driver's license.
Yeah. See, he might need to speak to somebody to get some counseling before going forward with that. And let's just run through the rest of these advanced directives real quickly. In addition to the medical power of attorney, there's a psychiatric advanced directive, and that is a document that you'd fill out if so you can communicate how you feel about being treated if you have a mental illness. There's a do not resuscitate order and the financial power of attorney. Illinois recognizes four documents. They recognize the advanced directive, the living will, the mental health treatment directive, And they also recognize the practitioner order or physician order for life-sustaining treatment. That last document, and we'll talk a little bit more about them as we go on, but the physician order for life-sustaining treatment is not an advanced directive per se. It works in tangent with some of the advanced directives, but Illinois does recognize it if you have one completed. That is, it's in your packet. It's in the living will packet.
Okay.
Yeah, all of the forms are in the living will packet, the ones that we'll be talking about. And this may kind of go to one of your concerns, Rosalind. Family members cannot veto an advance directive if it's signed and notarized. You know, so they can't change it. Sorry, I keep messing with my microphone. They can't change it or contradict the contents of it. And even if a person travels across state lines, most states will recognize and defer to a patient's wishes as long as those documents are signed and notarized. And that's important because, like, for example, when the body begins to begins to actively die, we don't need as much food as we once did, you know, when we were healthy. And a family caregiver might be alarmed by that and think, oh my goodness, you know, we need to get them on intravenous tube feeding. We need to do something. And not understanding that this is part of the dying process, they may try to contradict a person's wishes if they don't want to be put on a tube, you know, fed or a tube, by a tube rather. So your a living will that's notarized will make sure that your wishes are not overridden by your family's wishes. Oh, and the thing with, hi, welcome, have a seat. And I said this earlier too about when you're choosing your healthcare power of attorney, you want to make sure that you got somebody that's got a strong backbone, that's not going to bend to the wishes of somebody else if those wishes contradict what you want for yourself. You know, because some people may want you to be kept alive at all costs. You know, sacrifice quality of end of life for quantity. So that's a consideration that you want to just always, you know, keep in the back of your mind when you're picking, when you are choosing a power of attorney. And before we get into the forms, I want to talk a little bit about some of the benefits of having advanced directives in place. In addition to the ones we have listed here, that it ensures that your family members are aware of and adhere to your health care wishes, and lifting the burden of making those hard medical decisions from family members in an emergency. Advanced directives, to me, are an integral part of putting together your estate plan. And one of the common misconceptions about estates is that you have to have money in order to. If you don't have money, you don't have an estate. But if you have a car or a bank account or an insurance policy or own a house, you have an estate, you have assets, and you should have a plan for those, for those assets. But the misconception about what an estate is and who has one is something that robs many families of being able to transfer wealth from one generation to another. Because if we haven't planned for the transfer of those assets, then we leave the disbursement of those assets to the states. And you don't want to do that. Because there are situations that arise all the time where mom will say, okay, well, I got a house. I'm going to leave my house to Sam and Mary. Sam and Mary don't have a house. So I'm going to leave it to them. And the rest of the siblings are going to be cool with that. But what if the siblings aren't cool with that? You can wind up losing that house because you have to sell that house to pay the legal fees. You have to go to court. You have to open a probate case in order to execute the wishes that you laid out in the will. And so that robs the family of assets that could otherwise be used to transfer to the next generation.
For me, I like to collect hats.
Mm-hmm.
And some of
My
hats,
mom did too.
some of my hats are like artistic hats.
Uh-huh.
And that's one thing I want to leave. Like, if I can't give it to someone, it could go to like the Art Institute or the Chicago Historical Society or something like that.
Mm-hmm.
So I wanted to put that in my estate thing in terms of, it's not, money, so to speak, but it's like artistic heritage is what I want to do.
Yeah, that would go in your will.
So just put that in my will.
That would go in your will. Mm-hmm. And the thing with wills, I mean, that's for, gifts for beneficiaries, that's what you want to use your wills for. But if you got real property, real estate, you don't want to will a house to anybody. And I don't want to get into, let me just say this, I'm not a lawyer, so I'm not going to give you any legal advice. But what I have learned and heard and experienced is that putting the house in the will does not transfer the title of that property to the beneficiary. That only indicates that this is what you want done with it. The only way that you can do that you can transfer real property and keep it out of probate is with a trust, a revocable trust.
There's another way you can do it with the transfer of deed upon death.
Okay.
Yeah, which is called a toady. You can fill that out, and it doesn't have to be a lawyer. You take it down to the recorder of deeds and file the document there. And once that person dies, the owner of the property dies, you take the death certificate down to the recorder of deeds, and then the property will be put in your name. So I can give you some information on that.
Oh yeah, that absolutely need that, because if you can avoid paying a trust attorney to put that property in a trust, it's even better.
And that's a very easy process. I've done those, and they have that on the Rocket Lawyer.
Oh, okay.
Yeah.
Okay, great. I wish kind of too late in my case, but it's good to know and good information to share. But comprehensive estate planning is more than just listing your assets and beneficiaries. And estate planning lays out your plan for how you want to dispose of your assets. And you need to think about your body as an asset too. I think so. And then if you think of your body as an asset that you have to have a plan for disposing of, then you can then apply that same thinking to your physical assets. And that's what your estate planning is. And so the tools of estate plans include advanced directives, they include a living will, they include your medical, financial powers of attorney, your last will and testament, trusts, and the toady. Is it?
Transfer of deed upon death.
Transfer of deed upon death. Those are the documents that you want to have in place. And those documents will take the guesswork out of your wishes for asset transfer. You know, you make it really clear, this is where I want this to go, and this is how I want to be treated, and this is what I don't want happening when I make my transition. You can put your burial preferences, or not just burial, but, you know, remains disposal preferences. All of that can be included in your estate plan as part of your living will and your advance directives. And you actually wind up preserving your assets so that they can be transferred. Okay, so now we're going to get to work on the forms. We've talked about the healthcare POA, power of attorney. And your first document in your packet, oh, Sharon, here's one if you want to. It's a declaration of the living will. Now this is okay, the power of attorney for health care. There are features. What I want to bring your attention to, and I need to get one myself so that I can read it out loud. On the power of attorney for health care, things that you want, this is the first page, things that you want your health care agent to know. When you pick your power of attorney, you want to make sure that you discuss these items with them. And those items are, what's most important to you in your life? How important is it to you to avoid pain and suffering? If you had to choose, is it more important for you to live as long as possible or to avoid prolonged suffering or disability? Would you rather be at home or in a hospital for the last days of your life? Do you have religious or spiritual or cultural beliefs that you want your agent and others to consider? Do you want to make a significant contribution to medical science after your death through organ donation or whole body donation? And do you have an existing advance directive, such as a living will, that contains your specific wishes about health care that is only delaying your death? If you have another advance directive, make sure to discuss it with your agent and the treatment decisions contained within that outline your preferences. And make sure that your agent agrees to honor the wishes expressed in your advance directives. Critical. Absolutely critical. So the next couple of pages just outlines the type of decisions that your agent can make. Now, if there's something in here that you don't want, line it out. If you turn, and so all these subsequent pages are basically outlining things that, who you should choose, what if they're not available, and basically answering, some of the questions that people normally have. But the form itself is pretty short. So if you turn to the Illinois statutory short form, I don't know what happened. I must have deleted that slide. Sorry about that. Anyway, why don't we just take a couple of moments.
Okay, I don't see it. Okay, I'm looking right at it. I'm sorry,
Keep turning.
Yep, I had the short form. I just didn't read.
Okay. No problem. So that's why I provided pencils. So these are drafts. So feel free. We'll take a few minutes and Fill out what you can. Anything that you need to think about, maybe put a little circle or something next to it so that you know you want to go back to it. But you're going to print your name and your address. If you've already decided on who your power of attorney is, put their name and information here. And then you see at the bottom, it says, I authorize my agent to check only one box. If no box is checked, or if more than one box is checked, the directive in the first box will be the one that's implemented.
What does the box, if a guardian of my person is to be appointed, I nominated the agent under this power of attorney as guardian. Is that the person we're naming in the line before that? Section before that?
What page are you
The
on?
first page, still under my name and the person I'm appointing. It says, please check box if applicable.
Yeah, that would be the person that you're nominating as a power of attorney.
I haven't seen such good examples of people picking people to do things for them. So I'm thinking of having someone that's not related to me, sort of like an objective friend
Mm-hmm.
and such. And I'm thinking that this other person may want to know that I'm not picking them. I don't know if I want it to be a surprise that I'm not picking them, because I've never seen, of the two black women that have been in my life, I haven't seen a man be the kind of man to help, when it's that time.
Mm-hmm. Well,
I mean, I guess what I'm trying to say is, should a person know in advance that you're not picking them, and the person that you are picking, they should know that you're picking them?
I think that depends on your relationship with the individuals. I believe that you should share your documents with your key decision maker. But if I don't know, Dr. Thula, you have any thoughts about that?
You should share, especially with the person that you've chosen,
Mm-hmm.
and you should have someone facilitate that discussion with your family members, so they will know what is coming, so they'll understand what your decisions are, and there won't be that surprise at the end. And if they don't like it, I mean, there's nothing that you can do about it. once you chose somebody, that should be the person that you stick with.
But I've been really kind of devastated by, for example, I had this one friend, and she had a friend that was like there for her doing her medical stuff, but he was greedy and he was stealing, you know, like he had the documents and he covered them over and I signed them, but basically I was giving him all the stuff that, you know, I was giving him everything.
Well, that's why you have two witnesses, and you have a lot of stuff you have to have notarized. You don't have to have this living will notarized, but I notarize, I'm a notary too, and the responsibility of a notary is to make sure that what you're signing, you understand, and that no one is playing those games.
Well,
Right.
he played those games and got away with it.
Yeah.
One thing I want to point out to you on the second page of this power of attorney, specific limitations to your agent's decision-making authority. This is where you would add any caveats to the authority that you're granting to your power of attorney. Say if you don't want them to be able to release your body for autopsy or something like that. Whatever your specific issues are that you want to make sure that they can't, let me rephrase it, whatever your specific concerns are about your medical power of attorney, this is where that would go. And witnesses and notary.
I have a question.
Sure.
Who decides when this takes effect? Let's say you're in the hospital. Who decides that, now it's time to transition from you making decisions, laying in the hospital bed, to whoever you've assigned this to? What conditions have to be in place? Other than death, obviously.
You have to be incapacitated. You have to not be able to make those decisions for yourself. You either are sick, unconscious.
Cannot communicate?
You cannot communicate.
I see.
And that's why you do it in advance. I mean, because you can, if you notice on the form, there's a box that says, well, basically that outlines when it can take effect. You know, you might want to wait until you can't make any decisions or you're, in the state. Yeah.
You know what, and it's funny because I'm really uncomfortable with the statements. Like this statement that says the quality, like I want my agent to know my feelings on is the quality of life more important to me, or that part. But then the caveat that says if I am unconscious and my attending physician believes in accordance with reasonable medical standards that I will not wake up or recover my ability to think, communicate, etc. To me, that negates the whole purpose of having an agent if the physician is going to be making the decisions.
But the physician doesn't really make the decision on their own. If you have an agent, the agent is charged with making sure that what you want is what the physician must follow.
I would think just being in the healthcare school, like you take brain data and like you said, got you on a machine, you live your heart and stuff and everything, and it's going through the machine, and the doctor says, this person is not coming back.
Yep.
I don't think your agent say, no, we're gonna keep going with this.
It just depends on what you say, because there are directives that say, I don't care what's going on with me. I want you to do everything in this world to keep me
And I have
alive.
seen those forms.
And if that's your choice, but at some point, the doctors will just say, look, we gotta stop.
That's the point I'm.
We gotta
at
stop.
that point is what I'm saying. The
Yes.
position is, they, and believe it or not, insurance comes in there too, and they're like,
We ain't paying
we
nothing.
get the money, down the top. There's a lot of key figures that come into this play.
That's why your healthcare power of attorney, even though if you say, do everything in this world to keep me alive, and the physician says one thing, it's the power of attorney. If they wanted to do it, they would have to go to court and get a court order. If the doctors and the family was at the point where they said, look, you know, that woman that was brain dead, was in a coma for like 15 years,
Right.
they finally had to go to court to get the judge to order that the person be taken off life support. That's, you know, that's how involved it can get if you do something like that. But generally, it doesn't get to that point because somebody's brain dead and there's no hope. They will, you know, they're gonna die anyway. It might take 2 weeks, it might take 3 weeks, but generally nobody's gonna be laying up in a coma 15 years like that woman did.
Right.
And it just seems like that paragraph was made for insurance companies, that first little caveat part, like they went to the, when they was making this Illinois document, like they went to the, Capitol and made sure that got put in it, because that's an advantage for them.
Yep. Okay, so that's the power of attorney. We've got the Declaration for Mental Health Treatment. And this is basically 3 main issues. Do you want to be administered psychotropic drugs? Yes or no, if the situation warrants it. Do you want to be subjected to electric shock? If the situation warrants it, yes or no. And would you consent to being admitted to a mental health facility for 17 days if the situation warranted? Yes or no?
This one comes up under the healthcare power of attorney.
The Declaration for Mental Health Care, it's actually a separate, it's a standalone document.
Okay. But does it name anybody to be, like, have that power of attorney? I see where it says it has attorneys.
That would be the attorney in fact is basically your healthcare power of attorney.
Okay.
Mm-hmm. Because that's another phrase that's used to describe your agent. Your medical healthcare power of attorney is also called an attorney in fact. And at the bottom of page 3, you have to indicate that the person has to accept their appointment as attorney in fact for this mental health treatment declaration.
Question.
Yep.
So are these documents given to the doctor or the hospital? Because it seems like there has to be major communication between the hospital and whoever you assign as power of attorney. It's almost like they need to be there with you through your hospital stay, or does the doctor call you in if you end up being unconscious for a period of time and now they're thinking that, they may not come out of it?
Well, in my experience, the doctors have always asked if you have these. My experience, the doctors always ask if you have.
They have a copy. They will request a copy. Always had a copy on her, and the doctor's office always has a copy of the power of attorney.
That makes sense.
And physician.
Yeah. They have to know.
Generally, what you do is, that's why Cynthia's here and talking about this. You do it yourself. You get these documents, or you work with somebody like Cynthia who is putting these documents together, and then you give a copy to your doctor so that your doctor is aware. When you go in an ambulance, if an ambulance picks you up, the first thing they're going to ask you is, this person has a do not resuscitate. If you code in an ambulance and you do not have a do not resuscitate, then they will do everything, they'll resuscitate you. So you have to have that document with you almost at all times, a do not resuscitate. But the rest of the documents, the doctor is not going to hand you these documents and say, do you have these filled out? You get with a person like Cynthia, and she'll work with you to make sure that you have them filled out. And you have them in a place that when you get to that point, if you become incapacitated and the doctor is talking to you, you have this and say, this is my healthcare power of attorney. But the doctor, that's not a doctor's role, and that's not the hospital's role to sit down and do this with you.
Just in my experience, the doctor had a copy.
And that's because the person did it in
Because-
advance and gave it to the doctor.
You know, but I would recommend, though, you know, once you complete these advanced directives, certainly your healthcare power of attorney needs to have a set of these, but you should get a little, you know, a little file folder or something and keep them with your insurance papers, so that in the event that you have to be hospitalized, ooh, I always do that. Y'all know what I'm trying to say. If you do have to be hospitalized, those documents are available for the physicians and healthcare practitioners to see. Okay. So this last document in your packet is the one that I said Illinois accepts as an advance directive, even though it is not actually an advance directive. This Uniform Practitioner Order for Life-Sustaining Treatment, POWER, this form is used when you have a life-limiting critical medical event, and you could undergo a procedure that could threaten your life. This document is usually filled out in conjunction with a doctor or nurse practitioner or a medical professional. But basically, this document says, whatever you got to do to keep me alive.
As long as the insurance lasts?
And whichever runs out first. Okay. And that's all for this packet. Now, there are you have another set of documents here that I just want to bring your attention to. And these documents are called data collectors. These documents collect the information that you will need to provide to an attorney to have your estate plan done. That includes your advance directives. And the first one is your, oops, I got ahead of myself here. Your digital asset inventory. Digital asset inventory. When I first saw this form, my mouth fell open because I never really thought about all of the things that we have online. Some years ago, I put together a mail merge document that had all of my accounts, the usernames and the passwords and the account numbers and stuff that I have to periodically update all my bills. But that doesn't even begin to address your social media accounts, your, the insurance policies, any brokerage accounts or anything like that. And so this digital asset inventory forces you to sit down and collect all of that information in one place, so that the person that you appoint as your executor or your financial power of attorney can actually get into those accounts when you make your transition. Because there's nothing worse than having $20,000 in the bank. Nobody can get it until someone is appointed executor, or, but there's a way around that. And I just learned this. You can go to your bank and you can add what's called a pay on death rider to all of your accounts, so that when you die, the person that you nominate, because the bank has to have their name, their social security number, and their address, that person will actually be able to access those funds. You don't have to wait until an executor is appointed. I don't know if they require a death certificate. They probably would.
They do it.
They will require a death certificate, but that's all. You know, so instead of having funds tied up for could be months or even longer, it's called pay on death, POD.
And now it makes sense, I'm making a connection, because I teach, and I hadn't picked like an executor for like those funds. And man, those mails, the mails start coming once a week. I felt like they were bullying me. So I guess they was like, you know, it must make their accounting easier if it was a pay on death. Yeah, but they, you know, they kept reminding me, hey, you haven't picked anybody. You out of compliance with, you know, having an account with us. You know, like it was making it sound like we're gonna give you your money back. We don't even want to fool with you because you're not filling out this paper.
Yeah, you definitely want to make sure that you name your beneficiaries and that you have somebody on those accounts, so that, you know, when you transition, they'll be able to access them. But it collects your computer and phone information, your computer passwords, your email addresses. How many do you have? I had to write all my passwords down because you know, every account now requires a username and a password. And if you have your phone saving your passwords and your phone is password protected, ouch. Your social networking profiles. What do you want done with them? If you got an Instagram account, what do you want it to just live on in perpetuity? Or do you want it shut down? Do you have a blog? Do you have domains that you own? If you have websites, all of those things need to be recorded. Your online financial accounts, digital photos. Like this brother here has probably a gazillion photographs. What you gonna do with them? What do you want done with them when you're not here? So this is a really important document to have, but I would strongly suggest that when you fill this one out, you keep this one locked up. You keep this one locked up. This is not one that you want to be sharing with everybody, just with your key decision maker, or maybe your financial power of attorney. But yeah, you definitely want to go through and do that. The second document, your will questionnaire, was provided to you courtesy of Legal Shield. But I'm going to tell you, this document is pretty comprehensive. By the time you have finished this document, you will have you can just take the whole thing and say, okay, that's it. Seriously. Because that's what I did. You know, you give them this one document, they will create your will, your advance directives, all, like, depending on, you know, on your family situation. If you have a blended family, you got stepchildren or anything, all of that information goes in this form. Now, you may look at this and go, okay, well, yeah, that's all fine and good, but I don't have the money for a lawyer. I don't have the money for a financial advisor. And there are some low-cost ways in order to get this done, so that it doesn't cost an arm and a leg. You can take your drafts, You can do Rocket Lawyers, one source. You can do Legal Shield. There are ways, I guess the point that I'm trying to make is that there are ways to get this done that are less expensive. But don't let the cost of getting an estate plan and your advanced directives done stop you from getting it done. Because if you're 18 years or older and breathing, at the very least, you need to have your advanced directives in place. You got kids who are gone away to college, they need to have advanced directives in place because you don't know who they're hanging out with, who they're getting in the car with. Anything could happen. And like I said, because we don't plan, we rob ourselves of the opportunity to transfer assets from one generation to the other. So,
Question?
yes.
So you give this to the lawyer, they package it up,
Mm-hmm.
certify it somehow. Do they file it with the state? I mean, do they register it? I mean, how? They just make sure it's in proper order and give it back to you.
Yep, and then you get it notarized, and it's valid,
File it away.
and it's filed away.
Okay.
Now, a will would have to be filed with the county.
Before you pass, before you pass?
No, once you pass, so you wouldn't do it, but your executor or the person that you want to be an executor would do it.
So in Wayne County, 'cause that's where I'm from, in Detroit,
Okay.
you can register your will with the county while you're alive to help avoid probate.
But you still, and that's weird because you really don't avoid probate.
That's why I did the post.
Right. You don't avoid probate with a will, But I mean, I think it would be a personal preference if you wanted to try to register it ahead of time here. That I don't know.
That's how it is.
I haven't done any like pre-death type things, so I really don't know. Mine is in a box, with the notary stamp on it.
Well, once you complete the process, will they accept a digital copy of it?
Well, who accepts a digital copy?
Whoever you have to give it to, or do they have to have the physical printed with the ink stamp and the ink signature?
For the will?
Yeah, any of them. Well, it will or.
Well, for the
medical
will, you
power
have
of
to.
attorney or financial power of attorney.
I know for the will, they want the original copy. For the other documents, I think as long as if it's notarized, you can show them copies. I mean, they don't have to have the original. I think you would want to hold on to the original.
I have a will, and I have it in a safe deposit box,
Mm-hmm.
so I need to give the key to somebody.
Take it out the safe deposit box.
Excuse me?
Yeah, somebody has to have access to it. So
Take-
when you do pass, that somebody has access.
Yeah.
Because it can't
I
be.
have two copies.
Oh, okay. But you need to, who is your executor? Your estate executor, you would probably leave it with a copy with them.
Mm-hmm.
A living copy, and I put it in the safe deposit box.
If it's in the safety deposit box and nobody has access to your box,
Okay, so
Then-
I'll give them a key to go to the box.
it depends on.
It depends
I would
on the
give them
bank.
a-
Give them a
yeah,
hard copy.
I would give them a hard copy,
Okay.
Yeah.
because you never know what else you got in your box that you don't want anybody to.
I don't have anything else in there.
Oh, okay.
Yeah.
Well, you could put them on, because when you do get a box, you could put two people on the box, and you get two keys, so they could have a key and you could have a key, and just instruct them upon your death to go in the box and get your will.
Yep. Or you can give them a hard copy, and then you don't have to put them on.
Yeah.
Then you don't have to put them on your box, in case you decide to put something else of value in there. Oh, well, I was going to check my watch, but I think we're probably close to our time. Mr. Dolan, how much?
You got about 20 minutes left, I think.
Oh, okay. Well, good. So that pretty much ends our presentation, but let me just summarize. You want to record your wishes. You want to identify your key decision maker. That's really important. Fill out your forms. Fill them out and get them notarized. Every form doesn't have to be notarized, but it definitely helps. And share that information internally with your family if you want to. And to Darthula's point, it's a good idea to have somebody facilitate that discussion so that there's no surprises. And then, with your legal and or financial advisors. And then finally, you want to just pat yourself on the back because you did it. You got your estate plan done, you got your advance directives done, and you can just not have to worry about that anymore. And then you can go out and become an evangelist. And tell everybody ask everybody do you have your advance directives in place? Have you done an estate plan? So that we begin to share this information, and since women are the teachers, it's really going to be up to us to teach our family and our friends how important these documents are. So with that, I want to say thank you all very, very much for coming. And there's bags for you to put your stuff in so you don't have to carry them all loose. Let me get you one. Mm-hmm. And if you ever want to reach me, I've got some cards in here somewhere. Oh, one thing that I wanted to, this is the resources. Copy these websites down. So if you have any need for any additional forms, or you want to recommend information to people, that is where those are some resources that you can use. Okay. Okay, make sure I didn't write on this one. Now, I should have done I forgot to do a sign-in sheet. So if you would please just kind of put your contact information here. I'm going to do another workshop. It's going to be more polished and fuller and all that other good stuff. I'm going to have music and refreshments. Oh, gee, thank you. Yeah, write your name down so you can send me a testimonial. This is for the young lady behind the desk. Yes. Yes, please. I want your name, your phone number, your email address, first and last note.
First and last kid.
Yep. Pardon?
Dog's name and cat's name.
Absolutely. All your pets, passwords.
You work for the FBI?
Well, now I can't, if I tell you, you know what they say. So no, I can't divulge all my secrets. But you all have been really terrific. I do so appreciate each one of you for coming and putting up with my rather choppy delivery. But I hope that you leave with something, a little more information than you had when you came in. And I would really be happy to hear your thoughts. I'm going to send you an exit survey, so you can tell me what I need to work on, what you'd like to see in a future workshop.
And let's give Cynthia a round of applause.
Aw, yeah, so sweet. Thank you.